Hello, welcome to the IP Link headquarters, at least virtually. Thanks a lot for watching today. I get a lot of clients asking all kinds of questions about the patent process and how much it costs. Can I patent my idea or product? Why would I even want to? All these kinds of questions. And so I figured it'd be great to film this video and clarify a little bit, at least give that initial overview about the patent process. Now, one thing I'll mention just as I get started here is that I'm not a lawyer. Some of my clients find that refreshing. But one thing that I'll note about that is that nothing in this presentation should be considered legal advice. In fact, it should be, I'm coming at everything from much more of a business perspective than a legal perspective. So just make sure to keep that in mind as you're watching the presentation. And I'm guessing, most of my clients find this to be actually more valuable to them initially anyway. I mean, the legal perspective is definitely an important perspective to have, but I find it makes a lot of sense to sort through the business side of intellectual property and patents first and make sure you have a decent business strategy, how you're going to benefit from filing a patent, what are some of the costs, that type of thing, prior to jumping in into the legal side and working with a lawyer. So with that, I'll get started. And I've got a few images on each of the slides just of patents. This one you see here is a really, really old patent from the 1800s of a cash register. So some of my slides will have that. I might mention a few things about those too, just to keep it interesting. All right, so moving on to the first slide here. Just a quick overview of patents. So one thing that a lot of my clients and people that come to me, they're sometimes even a bit confused about the difference between patents and trademark and other forms of intellectual property, copyright, for example. So one thing to clarify is that patents are specifically put in place to protect an idea and more or less how that idea works, as opposed to, for example, copyright, which would only protect the exact words that you've written. If you're writing about an idea, for example, it would protect not the idea itself, but the words in that particular order, protecting people from copying and pasting. There are specific things you can file a patent on: products, inventions, processes is a big one. So processes, for example, including software in most cases. But there's some criteria you need to meet, which I will talk about in my next slide. One other thing that people often get a little bit confused or they don't realize is that a patent doesn't necessarily give you the right to use your own idea. That's sort of a separate question because there could be other patents out there that you potentially could be infringing on. But what they do give you the right to do ultimately, in the ultimate sort of end game, is preventing other people from using your idea. So something to keep in mind when you're approaching a patent, especially from that strategy perspective. They are pretty expensive and time consuming, especially compared to some other forms of intellectual property. But if you do it right and if you plan ahead, they can be pretty valuable. And I'll talk at the end of my presentation, I'll talk a little bit about how patents can bring value to your business specifically, and in particular, monetizing and recouping some of the investment that you have to put into patents to get them. I won't talk too much about claims in this presentation, but definitely book a call if you haven't already, and we can discuss that in a lot more detail, in particular with respect to your product or idea. But just keep in mind that on a patent, it's not necessarily just one aspect or version of your idea that you're trying to protect. You can protect multiple versions, and they typically last for about 20 years if you maintain them and continue to pay the maintenance fees and everything over the lifetime of the patent. So and I'll go into a bit more detail about timelines and costs and everything in a minute. And I've got an image here of a patent. You can see a US patent, what it kind of looks like. There's the abstract here, and the patent number up at the top here. So different pieces of the patent. This is one of the main images. This patent in particular is a dog toy. Basically, this inventor, can I read the name there? Yeah, Ross Eugene Long, I believe it is, back in 1999, wanted to try to protect a log with a patent. And actually it does look like this patent issued, or was accepted by the patent office, so surprisingly. But that's because, he's writing a whole bunch of crazy stuff about how this log has to have a branch in this one exact spot. But Anyway, that's kind of another funny patent there for you. So moving on, I mentioned that, it's difficult to get a patent, and it's not always, clear. Even when if we have an initial call and we chat a bit, it's not going to be clear from that initial call whether or not your product is patentable. I mean, we might be able to determine that it's not in an initial call, but you can never really say for sure in that amount of time whether it might be patentable, because you have to check these criteria. So the patent office will review all of the patent applications, including yours if you make one, based on a few criteria. So it has to be useful, and that some type of new use, in a sense, above and beyond existing prior art, but that sort of ties into the next criteria here. It has to be completely new. And this one's pretty tricky because, in the history of humanity, people have filed patents and published so many things, right? You can think of all the blog posts out there, all the tweets, all the existing patent applications. There's a lot out there. And so to give yourself some confidence that your idea is completely new can take a little bit of work, a fair bit of searching. So this is the bulk, or this is one of the steps that we go through in our process if you do decide to work with the IP link. And it's important to keep in mind here that when evaluating whether your idea is completely new, that includes whether you yourself have publicly released your idea already. So if you've published it, either on your website, or maybe you've told a third party or someone outside of your business about the idea without putting a confidentiality agreement in place, something like that, then the patent office will no longer consider your idea new or your product new. And in most countries, you won't be able to get a patent anymore sort of the day that you publicly release that, or at least the day after. So it's something, that really sets the timeline for when you need to start thinking about all this patent stuff. Because if you're planning, to publicly release your patent or your idea in a month or so, you want to get on things pretty quick, or at least, and I'm not saying you necessarily want to file a patent, but you definitely want to consider it very closely. And that's sort of the first 2/3 of our process that we take clients through. So it's important to do that. I usually say a couple months prior to when you publicly release your product is the best time to get started working with us, for example, or at least thinking about it pretty closely yourself. One thing I will say, though, that is in the United States and Canada, there's what's called this grace period. So you actually have an additional year. So let's say you're hearing this for the first time and you have already published your idea, but like it was 2 or 3 months ago, you have still the remainder of that year. So I guess if it was 2 months, you'd have 10 months left, for example, before you have to get that initial patent application in those countries that have the grace period. So that's US, Canada, I believe Australia, and a few other countries. But it's far better to kind of do this patent planning stuff, develop a strategy prior to your publication if you can. And then the third kind of big criteria that takes a lot of thought is whether or not your idea is innovative. And the patent office calls this obviousness. So they might reject your patent application because they would call it obvious from a legal perspective. And sometimes this is a little bit hard to nail down exactly what they mean. I've got these images here. So imagine you have this idea for a table where the legs come together first, and then there's this one pillar that goes up to the table, the surface of the table. Now, this obviously has already been done many times, but let's say you're the first one to come up with this idea. But in the prior art, there already are tables like this, where there's sort of this one flat surface and the legs go on the corners there. That would mean, and as far as tables go, that's all you can find in the prior art, or that's all you can find that's already been published. So then the question is, the patent office wouldn't be able to reject you due to novelty because this is at least a little bit different, right? But you keep searching. Let's say you start searching, or the patent office, let's say they search outside of these just tables, and they maybe find chair. Now this probably is out of order historically speaking, but let's say they find this chair where the legs come together like this first before going up to the surface part of the chair. They could use this reference in combination with the table reference over here to reject your application for this type of a patent because of obviousness or whether or not it's innovative. So that's something to watch out for too. It's a little bit more nebulous, and there's this process where you can argue against rejections that are due to any of these criteria, really. But it's an expensive process, and it's you want to have some confidence prior to investing really, too much money into the whole process, that you're going to at least have some hope of getting one version of your patent accepted by the patent office, even if it's a bit of a narrower version. And there's a few other things here, which I won't go into a lot of detail because we just don't have too much time. But definitely ask me about that if you want to book a call, or if you've already got a call booked with me. Now, the one nice thing about this is the patent office doesn't actually review your application for quite a few years into the process. So some of those costs that I mentioned where you're trying to argue against those rejections, they're not going to come up until a little ways into the process, maybe 2 to 3 years or something. Depends on each country, which country you're filing in. Depends on how backed up they are, all this kind of stuff. So what I will do is let's just erase that there. Oh, it's going to stay. Okay, that's fine. So what I'll do is I will give you a bit of an overview of the cost, because this is one of the most common questions I always get. How much is it going to cost me? How much is it going to cost? And I think a lot of people, think of it more like you pay your money, you get your patent, and you're happy, right? And now you can benefit from that patent in however you plan on benefiting. But that's not quite how it is. I mean, it's the costs are going to keep coming, and in fact, in a lot of cases, they keep building over the lifetime of the patent, which in some ways is good because you can sort of save some of the bigger costs for later, after you've built your business or developed a bit of a model to bring some of that revenue back in based on the patent. So and there's some ways to keep those initial costs a little bit lower. You'll notice that as I go through this timeline here, I've got a pretty big range on some of these costs, and that's because there's lots of different ways to approach it. So typically the lower range is a little bit more of a DIY approach, and you're taking a bit more risk there, especially as I get into some of the actual filing stages, which I will in a second, because if you're not involving a lawyer and you're doing this all yourself, you're taking a much higher risk, because you might miss something, especially depending on your how familiar you are with patents, etc. If you've worked with patents before, this is not going to be quite as much of a risk, and at least you'll be more aware of the risk that you're taking. If you've never done it, then you probably want to be working with a lawyer, certainly. Our process that I've mentioned a couple times, when we work with clients, definitely helps people prepare for their lawyer so that they can keep some of these costs, some of the costs that come around here and around here, at least a little bit lower. But still, I almost always advise, work with a lawyer, make sure you get a good quality patent filed. So the first thing you want to do is you want to take a closer look at some of these criteria, right? Before you put too much money into the whole thing, because if you find some existing patents or prior art of some kind, like publications, something else, then you might not actually want to move forward with the patent. So I usually say invest somewhere between $2,000 to $5,000 in this assessment stage, just developing the strategy, figuring out what you want to do. And this is really where the IP link helps a lot of our clients. I mean, a bit in this stage here as well, but we tend to focus a lot on this early assessment and strategy phase. So that's where some of that cost comes. There's other ways you can do this too. Some of the lawyers do a bit of a prior art search as well, which could cost in this range, but I find a lot more coming from the legal perspective as opposed to the business perspective, which is good. I mean, you definitely need that as well, but I think it's important first to figure out the business side. How are you going to be recouping your investment? What benefit is this going to bring to your business? What's your budget like? Do you have that planned out for these, at least first 5 years and then potentially longer? So anyway, that's the assessment phase. After you've done that, and usually I say start that a couple months before you want to publish, before you want to actually have that filing in place. And that's this. So, I've timed this. I've timed this timeline here for 0 years, being right when you put in your first first application. So you might want to start in the U.S. or Canada. Canada, I just say that because I'm in Canada and a lot of my clients are in Canada, but a lot of even Canadians and people, anywhere in the world do start with a US provisional because it's a little bit one of the cheaper ways to get started. So if you're really strapped for cash, cash initially, you can start with a U.S. provisional, and there's even a little bit more opportunity there to do it yourself and then clean it up a year later. Still, there's risk associated with that, but that would be kind of this lower end cost. Whereas if you jump in with working with a lawyer right away, which certainly, I recommend doing that for this initial filing, if you have, the money, then it's probably going to be closer to 10 grand, 8 to 10. I find clients that work with us, we help our clients prepare for this a lot more in depth. So, we'll draft a very detailed description with our clients, or the clients will draft it with our help, and it will be, it'll help get these costs down, maybe more in the middle ground, like 5 to 7 grand or something. So that's why there's a range here, of course. So this would be making your initial filing. And like I said earlier, there is a grace period in certain countries, but ideally you would do this before your first public disclosure. So right before you do that, maybe a couple weeks before, just in case things get delayed in the drafting process, because it can take a month at least to draft a proper patent, go back and forth, make sure it looks good and everything. So now you're seeing you're getting up here to 5 to 20 grand, and then a year later, so you make your initial application here. My drawing is not. That's fine. I guess we'll have that highlighted. You make your initial application here, and then a year later, you have to sort of formalize that in most cases. So if you started in Canada or in another country, you might not have to formalize that, but the U.S. provisional, if you start with that provisional patent, you'll have to clean it up, make it proper formatting and everything. If you filed before you've published, you still have the opportunity to file what's called this PCT patent. It's like a international treaty that gives you the opportunity to file eventually, actually up to a year and a half later, in a whole bunch of other countries if you want. So this is basically just a way of delaying the decision as to which countries do you eventually want protection in, because patents are jurisdictional. Sorry, jumped ahead there. So you eventually you're going to have to file in every country that you want protection in. Europe has kind of its own thing, but even there you'll still have to file eventually in each country that you want protection in. So this is where things start to get really expensive, which is why it's nice to get that initial application here at 0 years at a bit of a cheaper price, so that you can delay some of these costs. So hopefully within this first year you have either found a partner or an investor for your business, or maybe you've licensed the patent, and so now your licensee can help cover some of these future costs, or these additional costs that come up a year later. If you don't care about the rest of the world, maybe you're only worried about North America or even just your own country, then the cost at this phase may be a lot less. In particular, if you've already filed, let's say in Canada, and all you want is Canada, you might not have to do much at this phase. So something to keep in mind. Let's move on to the next slide here. So a year and a half after your initial filing, your patent publishes. All patents publish. So something to keep in mind. Your competition is going to be able to find that if they're looking carefully. I think probably most companies don't do really careful checks of this unless they have a big legal team or something. But something to keep in mind. And probably you've already published it yourself way back here. So this isn't really much of an issue. If you did take the PCT route, so if you decided to file a PCT here, then 2.5 years later, this is kind of where you have no real way of delaying which countries you have to file in at that point. But by now, hopefully, you've built your business up to the point where you're bringing in enough revenue that like 4,000 to 10,000 per country, a little bit more maybe with translation fees if those are applicable. It's not going to be a huge problem for you. And if it is, then maybe you should just drop this patent, or at least not file so broadly. Because if you couldn't get some investment or some licensee, or built your business to the point where you're making enough money to fund this at that point, then it might not be worth continuing to invest more and more money into the patent at this stage. And again, this is why you want to develop a really good strategy at this phase, so you're ready to go, and you can take advantage of this first year, and if you really need it, the second year here with the PCT. But a lot of my clients, focus on North America too, so they don't even file the PCT, which is again a little bit of a further savings. So then, when the patent office first starts evaluating your patent, this is sort of the first time they actually look at it with any scrutiny, and you might receive an office action, this, as they're called, which is just this process where they're arguing about your patent. So they'll reject your patent, or at least some of the claims or some of the versions of your patent. They'll reject it by saying, it's not novel, or maybe it's obvious, right? And you can pay your lawyer $2,000 to $5,000 per office action per country to argue against that if you think you have a good case. If you don't, then you say, all right, fine, claim 1, 2, 3, we're going to let those go rejected, but at least we've got a few claims, claim 4 to 7 or whatever it is that have been accepted, and that's if you're lucky, I guess. So it's a long process. It's an expensive process. You can see some of the totals there are getting pretty high. This $12,000 is sort of just like, I would be surprised if anyone could keep their costs down at this phase, to that. But I put it in there just adding up some of those low-end costs. I mean, maybe that would be a situation where your patent issues right away, which isn't always good either, because it means maybe you didn't try to get as broad of a patent as you might have been able to get, because you want your patent to be as broad as you can too, so that people can't just get around it. And then it doesn't end there either. So over the lifetime of the patent, there's going to be maintenance fees. These vary by country. Canada, for example, is a few $100s initially every year. US, I think the first one comes at about 3 years, and it's a few $1,000s, and then 7 years, it's like $7,000 or $8,000, and these change a little bit too. But definitely something to budget for and keep in mind over the lifetime. Maybe your patent will issue, great, but you still have to pay issuance fees and various other fees. Maybe you'll be rejected, hopefully not all your claims, but if they are, then you probably should have done a better assessment up at that initial stage. Sometimes things get rejected for unfortunate reasons. Sometimes the patent office finds an existing publication that's just so buried, like in another country, in a different language, and they dig it up and reject you, which is just not much you can do about that. So you never know until this stage, but hopefully that doesn't happen. And the more you prepare over here, the less likely that is to happen. And then after 20 years, your patent expires, and now, the deal you've made with the government is that anyone can use that idea, that product. So in some industries, 20 years is like an eternity. Software, for example. In other industries, you barely get the product to market before your patent expires. I'm thinking like biotech or different drug delivery markets. So you can see the total costs here. Especially if you file in a few countries, it can be pretty pricey. So you really need to have some plan in place to recoup this investment, and not just recoup it, but ideally you would be making a lot more, or you'd be receiving a benefit that is greater than the total amount you put into the patent, above and beyond if you hadn't filed the patent. And so I think my next slide here is, a little bit about, after going through all the risks and the costs and all the sort of negative stuff, why on earth would you even want to consider filing a patent? I'm not always the first one to tell you should file, but I'm a pretty big proponent for at least considering it, because I think a lot of businesses don't even think about it, and they're missing out on some opportunities to really level up their business. If they consider it closely, maybe spending that initial $2,000 to $5,000 to do a bit of an assessment, maybe work with the IP link, for example, or get a patent search or something done, or do one yourself. Putting that time in at least illuminates, it not only gives you some competitive intelligence, it also helps you figure out, could there even be any value there for our business? And it's really specific to your business. Some businesses makes a lot of sense to file a patent, some it doesn't. So I'd love to chat with you, in more depth. If you haven't booked a call already, there should be a link somewhere on the page or on the video that will get you to the page to book a call with me. And I'd love to talk specifically about how patents might be able to bring value to your business. But here's a few of the, I've listed a few of the most common ways that you can bring value to your business. And these are, a little bit different from what you might have heard, because again, I'm trying to come at this more from a business perspective than strictly a legal perspective. If you've talked to a lawyer, or even people sort of just familiar with patents at a high level, you've probably heard people say, oh yeah, it's great, you can sue your competition for infringement, and then you get this monopoly, right? Which is, I guess, the ultimate end game of a patent. But I find if you're suing anyone for any reason, you're probably, even if you win the lawsuit, you're probably losing in some way, financially, potentially, because your legal bills are going to be so high. Even if you win the lawsuit, you might not fully recoup your legal investment, because this can be, tens of millions of dollars, or who knows what the cost is there. So it's pretty expensive. So I say, even from when you first make that initial patent application, the patent pending status, there's some benefit already. So right away, you don't have to worry as much about confidentiality, because if you take the patent the whole way, now you've got that. You've had it in place. You can sort of prove that that idea was yours as of the date that you have filed that initial patent application. If your patent gets rejected because there's some existing patent or publication that the patent office found that was similar to yours, then you didn't need to be in confidential anyway, because it was already out there, right? So the reduced need for confidentiality, I find, is an important thing, and actually it brings. I think it helps reduce the stress of a lot of entrepreneurs and inventors in those initial days, because they're, quite worried. Okay, I can't tell anyone, right? But how can I move it forward without telling anyone? And sometimes that's maybe not entirely justified. It's probably better to tell people about your idea so that you can move it forward. Although, again, keep in mind, once you start telling people, you lose the ability to file a patent in most countries. So at least consider the patent prospect of filing a patent first before you start telling people, because then if you do want to move forward with a patent, it makes sense to file that before you tell anyone, at least outside of a confidentiality agreement. And then the other one, which is actually probably one of the biggest and least commonly thought about reasons for wanting to get a patent, is improved credibility. If you're planning on working with partners, or if you're looking for investment from angel investor or a VC, or who knows, any kind of a partner, if you can go to them and say, oh yeah, we're patent pending, we've checked that box, we've gone through the whole process, and we're ready to go, then that's going to immediately elevate you in their mind. They're going to think, wow, these guys are really pretty serious about this. They clearly put some investment into the patent process, because most investors know enough about that to know that it's not cheap and it takes some time. So they're going to think, wow, these guys are okay. Maybe they're pretty serious about this. And so they're going to be that much more likely to invest. Now, that's obviously not the only thing. You're going to have a pretty good business plan, some a decent market size, all the stuff. But patents are one small part of that really helps elevate your business. And also, if you put sort of patent pending on your website, or even if you're looking to hire, anyone you're working with is going to just think a little bit more of you. And a lot of the times this comes from the fact that these people you're working with don't fully understand the patent process either. Probably this far into my presentation, you probably know more about patents now than a lot of people out there. So they might think patent pending, oh, wow, there's, I better not mess, right? Which comes into on my next slide here, a few other benefits. But it's sort of like, if they don't understand the full ins and outs of the patent process, then just hearing that, it makes them, think even more highly of you than maybe they really should, because you're still at that early stage, right? You've only filed your application. Patent office hasn't reviewed it yet. They haven't accepted it. But a lot of the people that you might work with, they don't really know that. And they haven't read your patent anyway. So it's sort of like getting any patent application is actually great. It really brings a lot of value. And again, investor confidence. I kind of already talked about this in terms of credibility, but I like to list it here again, because it just, a lot of the clients I work with are looking to build their business into a company that's growing quite quickly, and for that they need investment. So, and if you're looking for investment on the order of few $100,000 and eventually on the order of millions of dollars with a seed round or a alpha round or something, then those costs are going to be dwarfed by, or the patent costs will be dwarfed by the investment you're looking for. So it sort of makes sense to put in that 10 grand or 15 grand or whatever it is initially, just to improve your chances of getting that investment. And if you're looking to work with any partner or anything, and you're negotiating, maybe you're co-developing some IP or some product, then having your background IP, all the stuff you've developed already, having that in place and very clear, it can bring a lot of value to your business, because when you're putting an agreement in place with your partner, you can say, okay, this we've already developed. So anything that's developed new, sure, maybe we'll share the revenue from that new stuff, but you can't claim to ownership or revenue from anything we've already developed. And that's important too. I mean, maybe your partners even have to give you a higher percentage of what you co-develop, because you're bringing a lot more to the table here. So something to keep in mind there as well if you're looking to work with partners. So one of the other ways that the patent can bring value to your business is by increasing the net worth. So if you're looking in the long term for potentially selling your business or having some other exit, this will definitely play an important part. Even if you're looking for investment, when investors try to determine based on how much they're giving, how much equity they should be receiving of your business, what percentage of your business, then they're going to be looking at what's the total current net worth of the business. And if you have some patents, though the value of those patents, since they're owned by the business, would contribute and increase the total net worth of the business itself. So that's definitely one thing to keep in mind if you're considering, where could we bring value from patents. And then I'll end with this one here because I like to just end on that note. But before jumping to that, I want to talk a little bit about the one which I mentioned briefly a minute ago. This is the idea that, the ultimate end game of patents being, you can prevent your competition from using that idea, right? And, ultimately, most people are thinking about, for example, suing their competition or sending cease and desist letters and just trying to prevent them in a really kind of negative way, I guess. And like I said earlier, I say this is not necessarily the best way to approach it, but you can still get some benefit. I mean, if you put patent pending on your website or maybe on the product itself, that's going to limit or reduce the likelihood that, especially some of the smaller businesses and players will just go right ahead and steal your idea. They might think twice, or they might actually approach you and ask about licensing, which is why I like to save licensing for last here. Or they might just walk away and say, okay, I'm going to just steal something from someone else because this guy clearly has a patent. And a lot of those smaller businesses, they're not going to be as sophisticated in their understanding of the patent process either. So they might see patent pending. They might not know exactly, what that means in terms of, oh, these guys could sue me tomorrow, or maybe they got to wait 3 or 4 years before the patent issues before they can sue me. They might not really get that, and they probably haven't read your patent either since it hasn't even published yet. So it'll just be enough to, reduce that likelihood that people will steal your idea. And it's also going to, give them a much higher likelihood that they're going to want to license your idea from you. So this is where, you give another business the right to use the patent in exchange for some revenue. So they'll pay you, and usually license agreements would come with a few different types of revenue that you'd receive. Typically there's an upfront payment on the date of the signing of the agreement. That could be, enough to recoup your prior patent costs, or maybe it's a few $100,000 depending on the product and how far along it is. And then typically people would also receive a license royalty. So the royalty is just a percentage. So whatever your partner or your licensee makes by selling your product, you would get some percentage of that. And oftentimes this comes in somewhere around 5%, but it all depends on what you negotiate, and it depends a lot on your product, your industry, how far along you are in the development of your product. So if you've just got an idea, and a patent application, then you're not that far along, so you're probably going to get a lower percentage. If you've got a product, actually one of my clients that I've been working with recently, his patent has already issued, and actually he's got a couple patents on this device that have already issued. And as you can see, he's built the device. This isn't just a prototype. He's actually been selling it. So he's sold this device for a number of years. Now he's looking to continue to grow that the number of products he's selling by partnering and licensing, ultimately licensing his patent to some existing companies, that then would have the ability to distribute and increase manufacturing and everything. But at least he's already got his manufacturing in place. He's got the product already developed. And so I could see him getting a higher percentage because he's further along in the process, and the fact that he's got an actual accepted or issued patent already really adds to it. So licensing is something that I find a lot of companies or clients that I work with don't really consider that prior to chatting with me. They're sort of planning on building this business. They've got this great product. They want to sell it and scale production, everything. But there's a lot that comes into play there. And if you're new to entrepreneurship, or if you're just a single person, it's probably difficult to do every one of those pieces by yourself. Of course, you could hire, you can partner, you can get investors, mentors, etc. But sometimes the licensing route is, an even better route, especially if you're the type of person who just likes coming up with new products all the time. It's certainly still a very involved process. It can take a long time to find the right partner and to put an agreement in place with them, but I would say a lot less of an investment and a lot less of a time investment than actually building up the company entirely yourself and selling the product yourself. So something worth considering pretty closely. And if you haven't, we've talked a lot about all sorts of stuff here. If you still have questions, which I'm guessing you do, because we haven't really talked at all about how any of this applies to your particular business, and it can certainly apply in different ways based on the different businesses and the different products. For example, if you have a software product, then a lot of this is going to apply in a different way, and in fact, there's some additional intricacies that are worth discussing. Versus if you have a consumer product or something else like a process. So definitely, I'd love to chat with you more. This is just meant to be kind of that initial overview, but please, if you haven't already done so, please book a call with me and we can have a little bit more in-depth conversation, talk a bit about where your business is at, some of the where you want to be, and some of the roadblocks that you might be facing in getting you there, and how obviously intellectual property and how patents could potentially help you get your business there. And then we can see if there's any way that the IP link or that I might be able to help you get there more quickly. So again, if you haven't booked a call yet, please do so. There should be a link under this video or somewhere. Please find that and just book a call, and I look forward to chatting with you soon. Thank you very much.